Welcome back to the big story. Well, the tax man cannot reopen an income tax assessment unless the department has new material. Now, the Bombay High Court has laid down the stipulation in two very recent rulings, one involving film star Amitabh Bachchan, the other on Rabo India Finance tax filings. Avantika now joins us here on the courtroom to take us through the takeaways in both those cases. Avantika, tell us.
That's right, Vivek. Now let me run you through the two cases and what the High Court said in each one of them. Now in the Amitabh Bachchan case, the Bombay High Court stated that reopening a tax assessment in the absence of fresh tangible material would be held invalid. Now Amitabh Bachchan had filed his income for the year 2003-2004 at 14.99 crore. However, he revised his income and claimed 30% as ad hoc expenditure, and when he was asked to substantiate this expenditure, Amitabh Bachchan withdrew his claim. Now the IT department determined Bachchan's income at 56.41 crore, and the IT department then issued a notice to reassess Bachchan's claim for the unexplained expenditure. Now, the High Court in turn observed that the law clearly states that the review under the garb of a reassessment is not permissible and therefore it was invalid. Now moving on to the case involving Rabo Finance, the Bombay High Court here too ruled that new material and evidence are prerequisite to open reassessment. Now Rabo India Finance had challenged the IT department's notice that was issued in 2011. The IT department contended that the 2004-2005 assessment of Rabo India needs to be reopened and the expenditure incurred by the Indian company as payments to its parent company Rabo International needs to be disallowed. The court in turn observed that the IT department had a change of opinion while reassessing these taxes for 2007-2008, and this could not be held as grounds for a reassessment. The High Court also stated that the material relied on for reassessment was procured by the IT department earlier itself but was not taken into consideration while passing the previous orders. Back to you.
All right, Avantika. Also joining us on the show to discuss this entire issue is Sunil Lala, partner tax dispute resolutions at KPMG India. Sunil, my first question to you, two significant orders coming in on pretty much a limited issue. Very significant according to you?
I think very heartily welcome judgments, and to really appreciate it, I may just give the background of the law. Really we have two sources of law. One is which comes from the parliament, which is the statutory law, and the other is which comes from the courts, which is what you call the judge-made law or the case law. If you go strictly by the statutory law, which is section 147 of the Income Tax Act, 147 says that if the AO has any reason to believe that income has escaped assessment, he may issue a 148 notice, reopen the assessment and reassess the income. Now that is the statutory law. Now, imagine a situation where an AO in the assessment proceedings is of the opinion that a particular amount is not taxable. He is transferred after some time and a new AO comes in the new place. The first AO has completed his assessment. The second AO is of the opinion, no, that particular amount which X thought was not taxable is taxable, and he reopens the assessment. Now, when you want to challenge that assessment, he's simply going to say, look, as per the statutory law, I have reason to believe that income has escaped assessment. And really, if you go strictly by the statutory law, he is right and he can reopen. Now, this is where in 1979, the Supreme Court in Indian and Eastern Newspaper Society case held that if there is a change of opinion, then really one cannot open the reassessment. So if a subsequent offer differs with the earlier officer in his opinion, he cannot reopen. Once this happened, the department got smarter. And then what they would say is, look, the first officer has not formed an opinion at all, because there is no discussion in the assessment order, there is no opinion, and therefore the Supreme Court ruling on change of opinion would not apply. Now that created another problem for the assessees, because how do we demonstrate that there is change of opinion? After that, in fact, this plea of the department was accepted by the Gujarat High Court in Praful Patel's case somewhere in 1998. And the Gujarat High Court agreed with the department that if there is nothing on record to show an opinion is formed, then there is no change of opinion and AO can still reopen. After that, we had the Delhi High Court judgment in the case of Kelvinator, which laid down some very interesting propositions. They said if you go by section 114E of the Evidence Act, then the presumption is that in a scrutiny assessment proceedings, the AO has applied his mind to the matter. Because section 114E says that all judicial acts are deemed or presumed to have been done properly. And therefore the presumption is that the AO has carried on his duty properly, he has applied his mind, there is an opinion formed, and therefore there is change of opinion. They also went further to say that for a moment let's assume that the AO has not applied his mind. Then really you cannot give him a premium on his lapse. No man can take the benefit of his own wrong. After that, there have been, so this is the importance, I must tell you the importance of this Bombay High Court judgment, both these. After that, the Allahabad High Court in the case of IMA India, the Punjab High Court in the case of Sevakram, the Kerala High Court in the case of Popular Automobiles, and the Karnataka High Court in the case of Renu Chakravarti. All of them took a contrary view, and they said that no, if there is, even on the basis of old material, the AO can reopen the mind. So they went against the principle of presumption, and they held that the assessee cannot take the benefit of the wrong done by the AO. So they applied the presumption in a reverse way. In this background, this Bombay High Court, both these Bombay High Court judgments have reiterated the position of Delhi High Court, the full bench judgment, and said that you cannot presume negligence on part of the AO. The presumption is that the AO has done his job well. If he has done his job well, he has formed an opinion and decided not to tax the amount, and therefore subsequently a later AO cannot tax the earlier amount unless there is some fresh new material. So in the light of this background, when there are contrary judgments in the case of Allahabad, Karnataka, Kerala and Punjab, I think this Bombay High Court judgment is very, very significant. Though I must also add that Bombay High Court has been fairly consistent. Even in the past, in several cases, whether it's Asian Paints, Cartany, German Feeds, they have been taking this view. But what makes this judgment more important is this has come after several other contrary judgments, and that's what makes it significant and heartily welcomed.
But Sunil, it still leaves open the issue that there are multiple orders, not all the same, coming in from various high courts. So do you think at some point of time there will have to be a more consistent view coming in from the Supreme Court, for example?
No, absolutely. You see, at the moment we have Calcutta High Court, Delhi High Court and Bombay High Court in favor on the proposition that in the absence of no new material, the AO cannot reopen the assessment. On the other hand, you have Allahabad, Karnataka, Kerala and Punjab, which says even if there is an inadvertence on part of the AO can reopen. So definitely this issue would have to be resolved by the Supreme Court. And the difference in the reasoning of both these judgments is a simple principle. Bombay High Court and Delhi High Court says that no man can take the benefit of his own wrong. So if the AO has not done his job properly, not looked into the old material, he cannot reopen the assessment subsequently, because then he's taking the benefit of his own wrong. He's getting an extension to complete the assessment or to reassess. The contrary view is that the assessee cannot take the benefit of the wrong of the AO. Now these are two diverse principles, and really the Supreme Court would have to really decide as to which is the correct principle. The second issue is on the issue of presumption. Both Bombay High Court, Delhi High Court are of the view that one can presume that the AO has done his job properly and therefore he has formed an opinion. On this very issue, the Delhi High Court 3 months back in the case of Usha International has referred this issue to the larger bench as to in which cases can this presumption be applied, and ultimately this matter would really have to travel to the Supreme Court to decide whichever ways.
All right, Sunil, we leave it there. Thank you very much for joining us here on Bloomberg UTV and elaborating on that very crucial judgment. Thanks very much.
Thank you.
All right, that's all the time we have in this edition of The Big Story. Thanks for watching, but lots more coming up here on Bloomberg UTV.